In this lecture, we would like to discuss another important concept, that is juvenile justice. So, as per the Juvenile Justice Care and Protection of Children Act 2000 and also the Act of 2015 is the subject of our discussion. So, first of all, we'll discuss the definitions of certain important terms under the Act as provided under Section 2 of the Act. So, the first one, that is child in need of care and protection. So, exactly the very scope of child in need of care and protection, that is provided under Section 29 to Section 39, and in particularly child in need of care and protection, which means any child who is found without any home or settled place or abode, and without any ostensible means of subsistence, and who is found begging, or who is either a street child or a working child who resides with a person, whether a guardian of the child or not, and such persons has threatened to kill or injure the child, and there is a reasonable likelihood of the threat being carried out, or has killed, abused, or neglected some other child or children, and there is a reasonable likelihood of the child in question being killed, abused, or neglected by that person. So also the child who is mentally or physically challenged, or ill children or children suffering from terminal diseases or incurable diseases, having no one to support or look after, and so also the child who has a parent or guardian, and such parent or guardian is unfit or incapacitated to exercise control over the child. So also the child who does not have parent, and who one is willing to take care of, or whose parents have abandoned or surrendered him, or who is missing and run away child, and whose parents cannot be found after reasonable inquiry, and so also the child who is being or is likely to be grossly abused, tortured, or exploited for the purpose of sexual abuse or illegal acts, and other such child who is found vulnerable and is likely to be inducted into drug abuse or trafficking, and also such child who is being or is likely to be abused for unconscionable gains, and also lastly those child who is victim of any armed conflict, civil commotion, or natural calamity, or and such child is considered that child in need of care and prosecution as defined under Section 2. So also we'll discuss about juvenile or child as it is being defined under this act. So those child which are falling under juvenile and child as defined under the act means a person who has not completed 18 years of age. So, after defining juvenile or child, you will go to juvenile in conflict with law. So, the child who is juvenile in conflict with law means a juvenile or a child who is alleged to have committed an offense and has not completed 18th year of age as on the date of commission of such offense. And now we'll discuss some other concepts under the act such as observation home, shelter home or special home as we found in detail in Section 8 and Section 9 of the Act. So, as regarding observation home, it means a home established by a state government or by a voluntary organization and certified by that state government under Section 8 as an observation home for the juvenile in conflict with law, and as regarding shelter home as it is defined under Section 37 means a home or a drop-in center set up under Section 37, and as relating to special home which is defined under Section 2, but the very scope is found under Section 9, means an institution established by a state government or by a voluntary organization and certified by that government under Section 9. And now we'll discuss about Special Juvenile Police Unit, what exactly it means as defined under the Act under Section 2. So, Special Juvenile Police Unit means a unit of the police force of a state designated for handling of juveniles or children under Section 63 of the Act. And now we'll discuss the very introduction relating to juvenile justice. So, as regarding the very definition of juvenile justice, society must be aware and vigilant about the protection of its children, because children are the future of the country and ignoring them could have serious consequences. The legislature of our country has enacted several statutes to deal with children in conflict with the law and to provide protection to vulnerable children through the Juvenile Justice Care and Protection of Children Act 2015. India has also provided a secular law for the adoption of children. So, we would like to discuss now certain landmark judgments delivered by the Honorable Supreme Court on the subject of juvenile justice and the protection of children. So now we'll discuss each landmark judgment. So the first one is Silavarsi versus Union of India, which was decided in the year 1986 by the Supreme Court. So this petition was filed in the Honorable Supreme Court for getting directions regarding the release of children below 16 years of age from jails. The petitioner, Silavarsi, also prayed for the production of complete information about children in jails and the existence of juvenile courts, homes, and schools in the country. The Honorable Supreme Court, acting on the petitioner of Silavarsi, directed State Legal Aid and Advice Board to send two lawyers to each jail within the state once a week to provide legal assistance to children below 16 years of age who are detained in prisons. All state governments to report the number of children's homes, remand homes, and observation homes for children in their states, and the number of inmates in each of those institutions. State to properly enforce the Children's Act enacted by them. They must file affidavits to show cause why they are not implementing those acts. District and session judges to make regular visits to the district jails and to take particular care of child prisoners. So also, the Honorable Supreme Court has the following directions relating to juveniles. In cases where a child has been accused of an offense that is punishable with imprisonment of a fewer than 7 years, the investigation must be completed within 3 months from the lodging of the FIR, and the trial must be completed within 6 months from the filing of the charge sheet. Children must not be lodged in jails under any circumstance. Remand and observation homes must be set up by the state governments. If there is no accommodation in these remand or observation homes, then the children should be released on bail. To ensure complete uniformity, the Union government should enact a Children's Act for the trial of children below 16 years of age and ensure rehabilitation of such children. And after the very judgment in this leading case, now we'll go to another important ruling, that is Hari Ram versus State of Rajasthan, decided in 2009 by the Supreme Court. Under the Juvenile Justice Act 1986, the upper age limit for male children to be considered Juveniles was 16 years. But the Juvenile Justice Care and Protection of Children Act 2000 treats children up to 18 years as juveniles. So the primary issue before the court in this case was whether Juvenile Justice Act 2000 applies to offences that have been committed before the coming into force of the Juvenile Justice Act 2000. The court held that upon conjoint reading of Section 2K, Section 2L, Section 7A, Section 20 and Section 49, it is made clear that all the persons who were below the age of 18 years on the date of the commission of the offence, even before the enforcement of Juvenile Justice Act 2000, would be treated as juveniles. It would be immaterial that the claim of juvenility was raised after the accused attained the age of 18 years. So, after that, we would like to discuss another important ruling of the Supreme Court in 2003, and that is in the leading case Jitendra Singh, alias Babu Singh, and another versus State of UP. So, in this case, the court held that anyone claiming to be a minor on the date of an offence should make such a claim at the earliest available opportunity before the trial court or the high court. But if no such claim is made for some reason, then that does not disentitle a person from raising such a claim before the Supreme Court. Juvenile Justice Act is a beneficial legislation and a technical plea like delay in making the claim of juvenility would not disavow a person from making a claim under the Act, but the burden of proof for making out a prima facie case for directing an inquiry into the plea of juvenility rests on the person who makes such a claim. And now we'll discuss another important ruling of Supreme Court in 2005 in the leading case Sampurna Beura versus Union of India and others. This case was primarily related to the implementation of Juvenile Justice Care and Protection of Children Act 2000 and Juvenile Justice Care and Protection of Children Act 2015. The court observed that children are the future of our country. They must be looked after. So it issued several directions to ensure proper implementation of the Juvenile Justice Act of 2015. Central and state governments must ensure that all the vacancies in the National Commission for Protection of Child Rights and the state commissions for protection of child rights are filled for the effective functioning of these statutory bodies. State-level child protection societies and state-level child protection units should take assistance from non-governmental organizations and civil society for proper implementation of the Juvenile Justice Act. State government must ensure the filling of all positions in juvenile justice boards and child welfare committees. Juvenile justice boards and child welfare committees must have regular sittings to ensure that there is no backlog of inquiries and children in need of care and protection are being taken care of. National and state commissions for protection of child rights must take up studies on various societal issues so that the state government can take remedial steps on those issues. State government must appoint the necessary number of probation officers for the effective implementation of the Juvenile Justice Act after getting reports from the National Commission for Protection of Children's Right or State Commission for Protection of Children's Right. Special juvenile police units must have been set up so that the police can effectively fulfill their role as the fast responder on issues arising out of offences committed by or against children. National and state police academies must consider including the topics related to child rights in their curriculum. State governments were advised to ensure that all the child care institutions are registered so that the issues of missing children and trafficking are addressed. Eminent persons from civil society must be appointed as visitors by state and union territory government to monitor and supervise the child care institutions. Members of the juvenile justice boards, child protection societies, district child protection unit, and special juvenile police units must be given adequate training and sensitization for the proper implementation of the Juvenile Justice Act. All the Chief Justices of the High Courts were urged to consider establishing child-friendly courts and vulnerable witness courts in his district to deal with inquiries under the Juvenile Justice and trials under the Juvenile Justice Act and the POCSO Act of etc. So now we'll go to another important ruling of Supreme Court in 2006, and that is Abjur Hossain alias Ghulam Hussain, state of West Bengal, where this Honorable Supreme Court held that the claim of juvenility can be raised even after the final disposal of a case. It can be taken up at any stage, and any delay in making such a claim cannot be a ground for rejection of such claim. The burden of proof for making a prima facie case supporting the claim of juvenility rests upon the person making the claim. Of juvenility rests upon the person making the claim. Production of any of the documents as referred in Rule 12 of the Juvenile Justice, Care and Protection of Children Rules 2007 will be sufficient proof to initiate an inquiry regarding the claim of juvenility. Affidavit of the claimant in support of the claim of juvenility filed for the first time in the appellate court shall not be sufficient to discharge the burden of proof for initiating an inquiry regarding the claim. The courts must not adopt a hyper-technical approach while dealing with the plea of juvenility. Frivolous claims of juvenility must be rejected, as it was held by the Supreme Court in this important leading case in 2006. And now we'll discuss another important leading case of Mumbai, and it was decided in 2007 by the Supreme Court, and the very leading case is Anjum Abdul Razak Menon versus State of Maharashtra, and it was through the special task force of CBI, Central Bureau of Investigation of Mumbai. So, in this case, one of the primary issues before the court was whether Juvenile Justice Act of 2000 prevails over Tata Act of 1987. Both these statutes provide that they will have an overriding effect over any other law in force. The Honorable Supreme Court observed that the Juvenile Justice Act aimed to have an overriding effect over laws that were in force on the date of its enactment. Tata had been repealed long back and was not in force when the non-obstantive clause was added to the Juvenile Justice Act. So the court held that Juvenile Justice Act 2000 would not have an overriding effect on Tata. And now we'll discuss another important leading case of Haryana, Jarnail Singh versus State of Haryana in 2010. Supreme Court held that for the determination of the age of a minor, a reference must be made to Rule 12 of the Juvenile Justice, Care and Protection of Children Rules 2007. Furthermore, it observed that even though the procedure mentioned under the aforesaid rule is meant only to determine the age of a child in conflict with the law, it can even be used for determining the age of a child who is a victim of a crime. And now we'll go to another important leading case. And the very decision was also delivered by Supreme Court in 2013, that is Salil Bali versus Union of India. And another, in this case, the petitioner had prayed the court to strike down the provisions of Section 2K of the Juvenile Justice Act 2000. This section defines juvenile justice or a juvenile or a child as a person who has not completed the age of 18 years. The Honorable Supreme Court discussed the rationale behind the said age limit and observed that the age of 18 had been fixed based on the understanding of experts in child psychology and behavioral patterns. So the court dismissed the appeals by noting that no interference was necessary with the provisions of Section 2K, which defines a juvenile or a child as provided under Juvenile Justice Act 2000 till sufficient data is available. And now we'll go to another important ruling, that is Shabnam Hasmi versus Union of India and others in 2005. Honorable Supreme Court held that due to conflicting viewpoints prevailing between different communities in the country, it was not an appropriate time to declare the right to adopt and the right to be adopted as fundamental rights encompassed by Article 21 of the Constitution. And now we'll discuss another important ruling of Supreme Court in 2014 in the leading case Dr. Subramaniam Swamy and others versus Raju Tiwari, member Juvenile Justice Board. And in this important leading case, the appellant contended that the provisions of Juvenile Justice Act 2000, specifically Section 1, Clause 4 and Section 2, Clause K, Section 2, Clause L and Section 7 must be read down to mean that juveniles who are mature enough to understand the consequences of their acts, who commit heinous crimes, must not come under the provisions of the Juvenile Justice Act. The Honorable Supreme Court observed that reading down the provisions of an act cannot be resorted to when the meaning of those provisions is plain and clear. There is no difficulty in understanding the meaning of the provisions of the Juvenile Justice Act. The Act has put all persons below the age of 18 in one class or ground to provide a separate scheme of investigation, trial, and punishment for offences committed by them. So the court does not need to read down the provisions, and it is one of the most important ruling and judgment of Supreme Court in this important leading case. Dr. Subramaniam Swamy and others versus Raju Tiwari, member Juvenile Justice Board. And now we'll go to discuss the last most important judgment in the landmark leading case in 2016 by the Supreme Court, and that is Srimati Rajni Bhatti versus State of Uttar Pradesh and another. Here, in actual, Parag Bhatti, a juvenile, through legal guardians, filed this appeal before the Supreme Court. So in this case, the court held that where any of the documents mentioned in Rule 12 of Juvenile Justice, Care and Protection of Children Rules 2007 are submitted in support of the claim of juvenility, then that must be considered to be conclusive proof of date of birth of the accused. But if there is a doubt and the accused is taking a contradictory stand, then the court could order an inquiry for the determination of the age of the accused. Such inquiry could include a medical examination. So, these are the landmark judgments relating to juvenile justice as regarding the very provisions of the Juvenile Justice, Care and Protection of Child Act 2000, also the rules of 2007 and the Juvenile Justice, Care and Protection Act of 2015 that we have discussed in length with all relevant and appropriate landmark judgments. Now we'll go to the very conclusion of this lecture. So, regarding the conclusion, we would like to discuss the Honorable Supreme Court has delivered a number of judgments on the subject of juvenile justice and child rights, interpreting and molding the law of the land in favor of the children in conflict with law. The legislature has also done a commendable job by standardizing the law on this subject. Now the primary task in front of us is to ensure the proper implementation of the law that has been laid down by the courts and the legislature. After all, as Honorable Justice S. Ravindra Bhatt said in one of his addresses, the true equity and justice of the society is how fairly it treats its children. So we have completed the lecture on juvenile justice.